Assalamualaikum warahmatullahi wabarakatuh. Good morning. Hi. We will continue with our part 3, right? Sale of goods. So let us go and see the slides, and I will explain to you slowly, right? Right. We continue from here. Okay. We stop at section 17 last time, part 2. So part 3, we will continue with privity of contract, right? You see, when we talk about contract, you knew this, right? You learned this already, okay? Contract means when the party agreed, right? They have all the elements, they enter into an agreement, right? And then they sign the contract, right? So the parties are the contracting parties, okay? Only those who sign the agreement are the parties, okay? Someone else who never signed the agreement is not a party. Okay? I sign a sale and purchase agreement with the seller to purchase a house. Okay? I'm the buyer, he is the seller. So we are the contracting parties. This is very clear. So now let us go to the general rule. Okay? So the term contract binds the contracting parties only. Okay? Thus, the term implied in the contract of sale are only between the contracting parties, buyer and seller, not someone else. Okay? And remember, I used to tell like, okay, if a person wants to divorce his wife, he must go to court and go with the proceeding and divorce his wife, right? He cannot go to court or he cannot ask someone to go to court and divorce his wife. He cannot do that, right? Sorry, my mouth dry. Okay, so let's say I purchase goods, all right? And then from 7-Eleven, okay? I purchased goods from 7-Eleven. I bought a drink. I drink, and then I fall sick because of that drink. Okay. Can I sue 7-Eleven? 7-Eleven is not the manufacturer. Okay? 7-Eleven is not a manufacturer. The 7-Eleven just sell the product to me. Okay? Can I sue 7-Eleven based on the contract sale and purchase? No, I cannot sue because 7-Eleven will tell me like, look, I'm not the manufacturer. You know, I'm just selling. Okay. If a third party use the goods, purchase, and injured because of defect of the goods, the third party cannot sue the seller. Okay? 7-Eleven has contract with the retailer. Retailer sell to 7-Eleven. They have contract like sale and purchase between 7-Eleven and retailer. Retailer and manufacturer. Okay? I am a third party. How do I sue? Who should I sue? Okay, then who will pay? Because I fall sick, someone must take responsibility. Okay? So since I don't have contract with 7-Eleven, okay, so I cannot sue 7-Eleven. I can't. Okay. Now, what should I do? So for this kind of cases, we will not go on the basis of contract, right? We will go on the basis of tort, right? The remedy that I should get is by suing the manufacturer who actually manufacturing the goods, all right? If the food is poisonous, can you sue the seller? The seller wouldn't know. You have to sue the manufacturer. Do you have any contract with the manufacturer? No, you don't. So we don't go on the basis of contract, but we will go on the basis of tort, law of tort, right? You will learn this, yeah? I just want to touch a bit on this. See, manufacturer to the distributor, to the seller, and the end user. right? There's no contractual obligation. The end user, if you see this, right, has no relation to this manufacturer, contractual relation. They don't have. So how can this end user sue the manufacturer under contract? They don't have contract, okay? So they can't. What they can do is sue the manufacturer under breach of care, under law of tort, okay? And law of tort, right, it is based on this case, Donahue and Stevenson, right? The case of Donahue and Stevenson provides the foundation for the modern law of negligence. Okay, now under the negligence, okay, under negligence, if there is any negligence, then there must be someone who is responsible towards that, isn't it? Like poisonous food that I purchase in the box I buy from 7-Eleven, right? So who is the responsible person? The manufacturer. Okay, now we will see on, we will look at this Donahue and Stevenson, because Donahue and Stevenson provide the foundation for the modern law of negligence. Okay, so if poisonous food, then we will sue under negligence. They are negligent. They give us poisonous food, right? Let us see the fact of the case. In this case, Donahue wanted to sue Stevenson, but he could not sue because the doctrine of privity of contract, right? Donahue, however, took the radical step of trying to sue Stevenson anyway. Okay. Now, Stevenson is responsible because Donahue, he purchased a drink, and in the drink, it has decomposed snail. Can you imagine snail decomposed already? You drink you drink all the bottle from the bottle, and then when you do like this, turn it upside down, come out a decomposed snail. How do you feel? Yeah, right? Ah, so he wanted to sue Stevenson, but they said that, look, you don't have any contract, all right? The doctrine of privity of contract says only parties can sue each other. So what is privity of contract here? I would like to go here again and make it clear to you. Privity of contract says that only the party who signed the agreement can sue each other. Outsiders, they cannot take part in the agreement. They can't, because of privity of contract. Okay? Now, let me go to the exact explanation on privity of contract. You know, it is a doctrine in a common law principle. Okay, it provides that a contract cannot confer rights or impose obligation upon any person who is not a party to the contract. All right? So if you are not party to the contract, you are not privity to the contract, right? No one can impose any obligation on you. Okay? Now we have, let's say, Bing Rui sign agreement with Afika, and suddenly Surah come and he wants to enforce the contract. He cannot. He's not part of the contract. Okay? Right. Now, so in this case, Donahue, when he saw that the composed snail, okay, he wanted to sue, but they said that you cannot sue because of this doctrine of privity of contract. But he took radical step. This is a very old case, yeah, and he still proceed to sue Stevenson. Okay, so when they go to court, as I explained much earlier, that if you go to court, there will be issue for the court to decide. Right? Why you come to court? Because we have this problem or this issue, right? Now, the question before the court was, right? Whether there are any ground upon which Stevenson could be held responsible for the injuries suffered by Donahue. That was the question. Can they make Stevenson responsible because of the injury suffered by Donahue, right? And then the court decided in that case that until today we use, right, this decision, the court decided that manufacturer who produce products that cannot be inspected prior to use owe a duty of care to customer of the product. Okay, so the manufacturer, the factory of Coke, Sprite, whatever, okay, all the foods, they have duty of care towards the consumer. If they breach the duty of care, which means they did not care for their food and something wrong with their drink, and when the consumer consumed, the consumer got sickness out of the food that the consumer consumed, okay, which means that the manufacturer has breached their duty, okay. This is what we call as neighborhood principle. Neighborhood principle means you owe a duty of care, okay. You are a manufacturer, you owe duty of care towards your neighbors, that is the consumer. If we drive on road, there are so many cars, right? We also have duty of care. We cannot hurt someone by our own negligence, okay? If we hurt someone because our own negligence, we did negligence, I drive so fast and suddenly I break emergency, all right, and cause hardship towards other users of the road, they can sue me based on contract because I breached my duty of care towards them, okay? In this case, Lord Atkins says that you must take reasonable care to avoid act or omission that you can reasonably foresee will injure your neighbors, which means we go back to my case where I drive, okay, I have the duty of care to avoid brake emergency without reason because I know if I drive very fast on the right lane, 120 kilometer per hour, and I simply brake emergency because I want to take my phone, use my phone, I should foresee that my act would cause injury to others, right? So I must take reasonable care not to do this, okay? Your neighbor is any person. Who is neighbor? So he says here, your neighbor is any person who is closely affected by what you do or fail to do. Neighbor is not your neighbor, yeah? Like my neighbor is doing construction, for his house, right? Not that neighbor. Neighbor is the person who closely affected from what you do or you fail to do, okay? So in my case, the neighbor is other user of the road, all right? According to neighborhood principle, a duty of care owed when a reasonable person could foresee that damage may occur as a result of defendant's action, which means that everybody knows if you drive very fast and you simply brake, you cause trouble to others. Or this is what people do, right? They simply change lane without giving signal. Suddenly they are in front of you and you have to brake emergency. Why? Because they do not give signal. You cannot read it, that they are shifting, all right? Okay. So we can foresee if we shift lane without giving signal, we can cause injury, we can cause accident to other road user, okay? So in this case, we don't sue under contract, but we sue under the law of tort because of this neighborhood principle because of neighborhood principle says that a person has a duty of care towards his neighbor. Okay, driver has duty of care towards other users. You walk in the mall, you eat banana, you have duty of care towards other person in the mall. You cannot eat banana and then the skin you throw like that and someone step on it. Okay. Not he, she fell ill and subsequently sued the ginger beer manufacturer, Mr. Stevenson. Okay, you can have a look at this. Okay, this is the fact, all right? So this is where the House of Lords held that the manufacturer owed a duty of care to her, and the manufacturer breached that duty of care because we can see, right, it is reasonably foresee that failure to ensure the product safety would lead to harm, especially when you have opaque glass. You cannot see. You cannot see inside. You try to see. You can't see. You don't know. So now make it a habit when you buy something, even try to look at it. Just try to, Normally we just drink milk, okay? Just drink. Yeah? Sometimes we even forgot to stir. So we should at least care. If I didn't bring this up, sometimes you just don't bother, right? All these things we have case law. Right, I want to go back to a contract again, okay? That was taught. If you cannot sue based on contract, you will sue based on tort. So we will continue with performance of the contract of sale, okay? So performance of the contract of sale, I would like to go for delivery, okay? So what is delivery? It means that voluntary transfer of possession from one person to another. Delivery means what? Food Panda delivery, voluntary transfer of possession from one person to another. They take the food from the possession of the seller and then give it to you. So you got the possession of the product then, the food. So you now got the possession of the product, okay? So delivery means voluntary transfer, okay? So we have to know that, delivery need not involve physical transfer. Transfer of title would suffice, which means that, right? Transfer of title would suffice, right? Every delivery need not involve physical transfer. This is relating to product that has title, okay? Like car, you have the title. When you purchase car, you have title. Or anything that you have title. So not necessarily you go and transfer the car. You can transfer the title first, okay? By transferring the title, you have already delivered, okay? We have section 36 section 1, right? Whether the seller is required to send the goods to the buyer or the buyer has to take possession of the goods depends on what has been agreed between them. Okay, this is very clear, okay? It means that it is upon the parties whether the seller should send it to you or you go and take it, okay? Whether you have, you need to use Grab or you go and take by yourself, all right? The general rule is this, okay? Goods sold are to be delivered. You have to deliver the good that you sold at the place at which they are at the time of the sale, or in the case where goods are still in non-existent, at the place of manufacture or production. So the good will deliver at the place of manufacture or production. Okay, but if you go to a mall, definitely you get the goods there, right? Okay, but this is the general rule. Okay, the good will be transferred, will be delivered at the place which they are at the time of the sale. At the place, at the time of the sale, when you go to mall, you purchase the goods there, and then they give you, you want to buy handphone, they give you handphone, right? That is general rule. Goods sold are to be delivered at the place at which they are at the time of the sale, okay? Mall. Or the good is not in existence yet. You order two what? 2 tons of watermelon, right? Then it is at the place of manufacture or production. Okay. That is the general rule. But then it's upon the buyer and seller to decide when or where they want to deliver the good should be delivered. Okay, where the good should be delivered. Section 36, subsection 5. Here, this is what I just said. Unless the party agrees. If the party agree, right, the expenses of an incidental to the putting the goods into deliverable state shall be borne by the seller. It says that if the party agree, unless you agree that you will bear the cost, okay, cost penghantaran pula, the delivery cost must be borne by the seller unless the purchaser agree to bear the cost. So normally when we use Grab food or whatever, we are purchasing, right? But we also buy. If we don't want to buy, we have to go and take it by ourselves. Basically, we don't have choice, but we say, okay lah, 5 ringgit, okay lah. Yeah? All right. Since we say, okay, we agree to the terms, and then we agree to the term, we proceed. Even though we do not say, I agree to the term, by our conduct, still using Grab food or Food Panda, okay, our conduct using that application, paying that by conduct, we agree to that we will bear the cost, right? Section 36(2). The seller must send the goods to the purchaser within reasonable time, okay? Section 37, subsection 1. You see, if the seller send the buyer the goods, but the quantity is not sufficient, it's not like what they agreed, the buyer can reject the whole goods. They send 3 containers, you have to count and everything, you know. If not, if it's not what you want, I mean the quantity is not similar with your order, you can reject all, okay? But if you accept at that moment, that means that you already agree to accept everything and you're bound to pay according to your contract. Okay, now, someone work with store. They have to be careful. When they receive the goods, they have to check. If they simply did not check, or they make mistake, or they are negligent, they are not doing their job, they accepted the goods, they sign and chop. That means the company they work with already accept. Let's say Giant. The staff of Giant accepting the goods. They did not check. And the good in quantity is not sufficient. Missing 2,000 goods. But the staff chop already and accept. When you chop and accept, that means you agree with the quantity. You have to pay according to the contract. Okay, if you see that it's not sufficient, you reject all. You don't want. Okay, that's what the law says. This is our rights, isn't it? Have you think about this? Do you know that the law provides for this? Have you learned this anywhere? I mean, by practice, we know. This is not sufficient, so I don't want to accept. You know. Normally, if you deal with trading, I mean, some of you selling online, whatever, you know, all those things, right? This is what you do in practice, but you never know the law. So now you learn the law. Remedies for breach of contract. Okay. The right of seller in a situation where the buyer breached the contract. So what are the seller's right under SOGA if the buyer breach? Okay. Right of the unpaid seller against the good. The seller has the right to get back the goods if the buyer do not pay. And then the seller also has the right to sue the buyer for breach of contract. So you don't pay, you breach your contract. So they have the right to sue you. Now, right of buyer in situation where the seller breach contract. Now, we want to know this. Now, some of you do online business. They would like to know the right of buyers. But many of us, we have no business, isn't it? We just want to know our rights. So what are our rights? What are the buyer's rights? So this is the right. Have a look. Follow me. I mean, I haven't done that follow me advertisement yet, so we'll start with follow me. Right. I hope that you are following me anyway. Right of the buyer to sue for non-delivery. Okay. They did not deliver until 1 month they promise, you have the right to sue. Okay. And then for certain products, you can go for specific performance. Force the seller to send you the product. Okay. And then whatever remedies that you can get if there is breach of warranty. Okay, there is breach of warranty. We learned about warranty already, isn't it? So you can sue for remedies, for payment. Okay, and then the buyer also have the right to proceed, to initiate proceedings or initiate cases against the seller according to law of tort. That's why I share with you law of tort. It's part of this. Now, sales by non-honest. Nemo.quote non-habit, right? No one can give what he has not got. You didn't get it, it's not in your hand. How come you give it to me something which you do not have? All right? This maxim is this principle is very, very important because it protects the ownership of goods in the way that if goods are stolen, someone steal it from you and then sell to your friends, your right intact. The good is still yours. Yeah, you have still the right. The right of the owner is retained. Okay. We have this under common law. We have this Nemo.quote non-habit. Under the Sale of Goods Acts, we will refer to section 27. Okay, it says that where goods are sold by a person who is not the owner, right, and who does not sell them under the authority, you're not the owner, or you has no authority to sell, or you don't have the consent of the owner, the buyer acquire no better title to the goods than the seller had, which means that the seller has no right over the goods. The buyer who purchased from the seller also has no rights over the goods, right? Because we will see that the general rule says that no one can transfer a better title than he has himself, right? It means that if the goods are purchased from the person who is not the owner, you just purchase, someone is selling. Last time it was maybe you were kids, we do have issues, and maybe in certain area only, drug addicts, yeah? They like to steal and then sell very cheap, right? If you purchase from that kind of person who has no rights of ownership over the product, if you purchase from that person, you also do not have the rights on the product, right? So it says that if the goods are purchased from a person who is not the owner and who does not sell them under the owner's authority, the buyer does not acquire title, even though you pay good money and you buy in good faith. You see someone selling, buy, please, buy from me, please buy from me. I need money urgent. We don't know where he got that from. Yeah, we don't ask him to prove that. For example, yeah, gold. Gold has the, something like title. Yeah, a receipt that says that the gold is the weight of the gold, the value of the gold. When you purchase, you have to keep that. Make it a habit. If you purchase, keep that. Even though someone purchased from you, you ask to keep that. If you want to sell back, you bring it. People know that is yours. Yeah. So they just sell and you never check, and then you purchase, and then the owner come after you and say that no, someone stole from me, and they start a police case for no reason. You have to be in police together with them to deal with this matter, right? Yeah, here, okay, I would like to stress that goods that sell by a person who's not the owner, right? Not the owner means then you are not the owner, you do not have authority, you do not have consent, right? Then the person who sell a goods, this person who has this characteristic, sell a good, right? That goods is purchased by us, by us, and we pay good money in good faith, not knowing that he's not the owner. Still, we do not have the right over the goods. Okay, this is to protect the honor of the goods. Okay? This is to protect the ownership, right? So I would like to go here, exception to the general rule. That is the general rule. It says that if you are not the owner, you have no authority, you don't have the consent from the owner. When you pass the goods, you deliver the goods to the buyer, right, to the purchaser, to the buyer, to the purchaser. The purchaser do not has good title. Okay, do not has good title. Now we have exception to that. That was the general rule. So now we have estoppel, right? So section 27 provide that the nemo that rule is not applicable when the real owner of the goods by his conduct precluded from denying the seller authority to sell. We learned estoppel already, right? When you are the owner, okay, we are there, right? We are there, me and you, we are there in an occasion, and then I took one of your property, and then I try to sell to someone beside me. You look at me and do nothing, right? And then that person purchase, right? Thinking that I'm the owner, you will be stopped from denying that I am not the owner, I have no authority. Okay, that is estoppel. Okay? If you read, the explanation is similar is what I said, right? Even though, you know, even though that I'm not the owner, you did not stop me. And after I sold to the third party has good title. Why? Because you're supposed to stop me from the very beginning, tell the third party, look, she has no authority, this is my property. But you didn't do that, right? Okay, you're being stopped. You're being stopped from claiming your rights after that and claiming I'm not the owner. So I cannot sell. That's number one. Number two, sale by mercantile agent, right? So if a mercantile agent has in possession of the goods, right, with the consent of the owner, and then he sell the goods when acting in the ordinary course of business of mercantile agent, that person who purchased from him has good title. Okay? Because he has an agent, yeah? Because an agent has the authority to sell, right? And when he has the authority to sell, he also can convey good title, okay? Sale by one of the joint owner. By virtue of section 28, if one of the several joint owner sold possession of the sole possession of them by permission of the co-owner, the property in the good is transferred to any person who buys them in good faith and has not at the time of the contract of sale noticed that the seller has no authority to sell. It's like this, okay? There are 5 of us, okay? We need transport. So we purchase a car, right? So that we can use to go to college, to UPM, and to go out to eat whatever. And then all of us agreed. We say that, Abu, you hold the key. Okay, you take care of the car, please. But the car belongs to all of us, right? Family member, husband and wife, right? The wife say, husband, you know much better about car. You keep it, right? So it's in the possession of the husband, right? I like to say that the possession is someone who live not within the surrounding, okay? Either one, right? When the husband has the authority or Abu has the authority to hold, have possession of the car, right? And without telling the partners, the co-owners, the one who has the possession sell the car, right? Abu later on sell the car to a third party. And that third party purchased in good faith. And he does not know that Abu has no authority to sell. He thought that, okay, right, he's holding, then he has the authority to sell. And the third party purchased the car, right? So in this case, the third party has good title. You cannot say that give back, you don't have good title. No, the third party has good title, right? This is in pursuant to section 28. Right? So the exception to the general rule, because nemo dat court non-habit, it says that no one can give what he doesn't have. So then we have the exception, and the ground principle regarding the transfer of title will refer to section 27 to section 30 of Sale of Goods Act, right? So these are the sections. We continue with sale under voidable title. So according to section 29, okay, if the goods obtained under contract voidable, you know voidable contract, right? Voidable contract means the contract entered between two parties. One of the party actually misrepresenting, and at the moment the other party knows that there is misrepresentation, the contract becomes voidable. It is at his option, he can choose whether he wants to proceed or he doesn't want to proceed. If he knows that the contract is voidable, right? If the contract is voidable, okay, and it has not been cancelled, right? It has not been cancelled. The person who acquired the goods acquire good title, right? The person who purchased from a contract voidable has good title if he purchased in good faith and he has no notice of the seller defect of title. Like Abu, he sold the car to third party. Okay, he sold the car to the third party, and then I don't want to use Abu, I want to use Ali. Like Ali, he sold a car to a third party, and then when he purchased the car, if I use Abu, you got confused, right? So if he sold a car to a third party, that car actually he got from Abu. Ali got a car from Abu, and he actually, what he did, he cheated, he misrepresented, okay? He tell Abu, the car is worth 5,000, not more than that. Actually, the car is worth 15,000. Because of misrepresentation, Abu sold the car to Ali, right? Abu sold the car to Ali. Now, Ali got the car and sell to a third party, okay? And then Abu realized, this is misrepresentation. My contract should be voidable, right? So that voidable contract between the seller and the earlier person, okay, has not been cancelled, has not been rescinded. And that seller sell to another person, Aini, right? When Aini got the car, she got with good title, right? Why? And when she purchased in good faith, and she never has information that the car that sold by Ali to Aini, to her, actually from a voidable contract. She has no knowledge. This is section 29. I'm not sure whether you are clear with this or am I confusing you more. Can you repeat this part if you're confused and then still confused? Let me know in our next class so I will explain to you, right? Section 19 of Contract Act refers to avoidable contract. Okay. Coercion, fraud, misrepresentation, undue influence. Okay. Section 20, undue influence. All right. Undue influence is easy, right? Like lawyer and client. The lawyer purchased the land from client with cheap price, sell to another person with higher price. The person that purchased the land has no knowledge that the lawyer acquired the land through voidable contract because undue influence, isn't it? So voidable contract. So the purchaser has no knowledge. The land that the lawyer sold to him is from voidable contract, which has not been cancelled, which has not been rescinded. And the purchaser has no knowledge. Also, the purchaser has good faith. So the purchaser can has good title, right? Sale by seller in possession after sale, right? Section 30, subsection 1. A seller who has parted with the title to the goods but remain in possession of the goods can pass a good title to a bona fide buyer. The secondary buyer gets a good title, whereas the original buyer loses his and has to claim remedy against the seller. It's like this. Huh? When I'm selling car, I have a company sell car, and everybody is asking for my V. I see that, okay, I sell to one. I sell to one. One, I'm selling you this car, and then one purchase. Okay. So I said, okay, now leave the car, just take the title because we want to do something and then we send it to you. One say, okay. He took the title, he went back and called me and said, look, Anna, I'm going overseas for 2 weeks. And then he's stranded there because of COVID, right? I still have the car with me. And the car, the demand is very high. I was thinking like, I prepare another car for him lah. So I sell the car in my possession to another person, to the third party. So that third party will have good title. We have a case about this, okay? This is just something to explain to you what section 30 subsection 1 stated, right? Sections, okay, sale by a buyer in possession of goods. Okay, first in possession after sale. After he sold, he still have possession, either title or the property. He can, if he sell again, 30 subsection 1, yeah? If he sell again, the buyer will have good title. Now sale by a buyer in possession of goods, right? Section 30 subsection 2. A buyer who have bought the goods or agreed to buy the goods and then obtain possession of the goods or document of title with the consent of the seller can pass a good title to an innocent buyer under any sale or disposition, which means it is like this, right? I purchase a car. I always use car, okay? I purchase a car because car has title, okay? Yeah, motorbike, a lorry, van, whatever lah. What you like, you can change it in your mind, right? So I purchase a car, and then I tell the owner, okay, I'm purchasing. I pay 5,000. They say, okay, Dr. Hannah, we'll give you the title within 2 days, whatever. After I tell them that, immediately I find a buyer. I sell the car to the buyer, okay, and this buyer will have good title. Right. I want to go to this Ngat Siang and Arab Malaysian Finance. Okay. Now look at this. Plaintiff bought a car from second defendant. Okay. Before that, let me explain to you. If you haven't buy a car yet, or you don't care what happened to your parents when they are busy, talking about their car, the title or the loan, whatever, you just don't care. So you don't know. Let me tell you something. Okay. When we purchase a car, if you have cash, no issue. Just pay and then bring the car back. Right. Now, if you need loan, financial assistance, right? You go to the bank, right? You go to the bank. You will learn in hire purchase. We go to the bank and tell, first, go to Produa. Produa always in my heart lah. Not because I don't like Mercedes or whatever, but I just like Produa. Okay, it's a matter of choice, isn't it? Right. So we go for Produa, and then I choose one car. Right. I said I still my V. I love my V so much. Right. I can drive very fast with my V. 160 still can go my V. Right, but not now. When I was young girl. So I go there and I purchase my V, right? So I tell them, look, I want this car, okay? They say, okay. Now we will try to find financial assistance. So I go to CMB and said, I need a loan. I will pay 10,000. I need another 40. They said, okay, doctor, we'll pay 40. You have to, we'll take the car. We purchase the car from Produa, and then we sell it to you. I said, okay, and you will pay us monthly until you finish payment. We will give the car to you. We will give the title to you. I said, all right. Okay. When we purchase a car and we take loan, we take the car back, but the title is not with us. It is with the bank, okay, with the financial institution. They will keep the title, proof that we are indebted with them. Even though if they don't keep the title still has their name chopped there. Okay. So now, until we finish payment, then only they give us the title. So let's say I purchase a car and then I want to sell a car to another person. Right? Now I don't like Produa anymore. I said, I need Honda. Right? I need Honda because I think more comfortable. So I changed my heart already. So my sister said, Hannah, why don't you sell me your car? I said, okay, fine. So now I want to sell my car to my sister. What I have to do is to settle the balance. To settle the balance with CIMB, right? With CIMB. So what happened? I'll tell CIMB, give me the balance, how much I should pay. They said, okay, another 20K. So I tell my sister, another 20K you have to pay. My sister said, I don't have money. I'll go and get loan from Maybank. So she go to Maybank, bring that amount and tell Maybank, I want to purchase this car. This is the balance. Can you pay CIMB? Maybank pay CIMB. Maybank pay CIMB, then CIMB will give me the title. I take the title, cancel CIMB bank names, put my sister's name, and then put charge on Maybank, give the title to Maybank. That's how it goes, if you don't know. Okay? If you know, then don't get bored. You know, it's not boring to listen sometimes again and again. It's to enhance our knowledge, right? Take it out. So now in this case, the plaintiff bought a car from the second defendant, right? So for plaintiff to get the title from second defendant, because plaintiff bought, second defendant sell, right? To affect the transfer of ownership of the car to plaintiff name, okay, to transfer the ownership title to plaintiff name, first second defendant has to settle the loan with MUI Finance because he got money from MUI Finance to purchase the car. Hire purchase facility. We will learn about hire purchase later, right? So first settle with MUI Finance. Okay. So now when plaintiff bank pay to MUI Finance, the second defendant must take the registration card, the title, right? He has to cancel the name of MUI Finance ownership. On the title, I said that the name of the bank will be there, right? So in this case, he has to go and cancel the MUI ownership, right? So what second defendant did, after plaintiff paid to MUI Finance, he took the title, he cancelled the name of MUI Finance, it become only his name, he sell to another person. Okay? So second defendant sold the car to B. And B, when he purchased from second defendant, he take the loan from the first defendant. Okay? He take the loan from the first defendant, right? That is Arab Malaysian. So B purchased car from second defendant, taking loan from Arab Malaysian. Okay? That's why in this case, plaintiff sue Arab Malaysian and also second defendant. Because the title now is under the name of Arab Malaysian, because B financial, and also second defendant, he sued because he paid to second defendant supposed to give it to him, but did not give, right? Now, when Arab Malaysian pay the money to second defendant, right? So that B can have the car, okay? Plaintiff got to know this, and the plaintiff sue Arab Malaysian and also second defendant. Plaintiff go to court, sue, because he wants the court to determine whether Arab Malaysian has good title of the car. Whether Arab Malaysian is the third party who purchased with good faith, and can have good title. Like the cases fall under the general rule, remember I discussed just now? So he wants the court to determine this. Right. To that end, the first defendant acquire no title. The court said that the first defendant acquire no title or interest over the car when they purchase it, and Arab Malaysian do not have good title. The court said that Arab Malaysian has no good title. If they want, they can go for remedy, which means they can sue second defendant lah. Huh? They can sue second defendant personally, okay, for the return of the purchase price, but they cannot claim ownership. The court said that, look, Arab Malaysian does not have good title. Okay, the title remain with plaintiff. And if Arab Malaysian want their money back, they have to sue second defendant personally. Okay. They said that plaintiff in this case, you know, if you just keep quiet, do nothing, then if in this case plaintiff keep quiet, do nothing, then Arab Malaysian can have good title. But in this case, what happened was plaintiff keep calling second defendant. Hey, have you paid? When can I have the title? When can I have the title? And then when he think that the second defendant took a long time, he lodged a police report. All right? He's not negligent. It's not like let the person retain the possession of the car. No, he did not. He is not negligent. And then he make a police report. Okay? So the first defendant has only themselves to blame for the loss suffered when they parted with the purchase price and not being purchaser for value without notice of no relevance to the facts of this case. So the court said that, okay, then it's the Arab Malaysian loss, Arab Malaysian finance loss, right? They don't know actually what's happening, so it's their loss, right? If they want, sue the second defendant. Okay. If you can remember, the character in this case is the plaintiff, second defendant, the purchaser, B, name B, and the purchaser financial, Arab Malaysian. Okay. So this is the case 1988. Section 30, subsection 1. Okay. This provision means that it should the seller sell the goods that was bought by a previous buyer is still in the seller's possession to a second buyer, The second buyer will obtain a good title to the goods he bought from the seller in good faith, right? The first buyer will lose his title on the goods, but he is entitled to sue the seller who would be liable to him. Okay, so if a seller sells goods to you, and then you haven't got the possession, whatever, they took the goods and sell to another person. That another person has what? Has good title. You cannot ask for the goods anymore. But what can you do? You can sue them. Then they can be liable. You get your money back, but you do not get the goods. Right. So I know it's a bit, when you come to this kind of cases, you feel dizzy, isn't it? What is this, But you see that, listen to Nelson Mandela, I like this. It always seems impossible until it is done. And this is a recording, you can always listen again and again. If you do not understand, do not hesitate to bring the question to me in the class. I will answer your question. Okay, thank you very much. Wabillahi taufiq wal hidayah. Assalamualaikum warahmatullahi wabarakatuh. Have a good day, everyone. Bye-bye.